रबड़ बैंड
वही तो कानून है उसे प्राइवेट कर रखा ना तुमने कल पब्लिक है ना
मैंने तो कल का सेट नहीं करा था फिर तो लिंक
Please be seated. A very good afternoon and welcome to the final round of the 14th edition of GIL National Moot Court Competition 2024. I am truly honored and privileged to welcome our honorable judges and participants to the final round of 14th GIL National Moot Court Competition between TC 09 and 21. It is indeed a privilege for me to introduce the honorable judges for the final round. For the final round, we are honored to have the honorable bench of Honorable Mr. Justice Jasgurpreet Singh Puri, Judge, High Court of Punjab and Haryana, Shri Pratap Singh, Member, Bar Council of India, Ms. Savitri Pandey, Senior Mediator and Arbitrator, Supreme Court of India. I once again welcome the esteemed panel of honorable judges who, despite their busy schedule, have taken time to preside over today's final round. I now request the court masters to begin the proceedings with the prior permission of the honorable court. Thank you.
Good afternoon, judges. I welcome you on behalf of the Institute of Law for today's 14th GIL National Legal Competition in 2020. Permission to collectively address the bench as your lordships. Much obliged, your lordships. Permission to start the session. Much obliged, your lordships. Good afternoon, everyone. I welcome you all for the final round of 14th GIL National Nuclear Competition 2024. We will be your court masters for this session, and here are some instructions for the round. The total timings for each team will be 45 minutes. Each speaker shall plead for maximum 25 minutes and minimum 20 minutes. The timings for rebuttal and sur-rebuttal are inclusive of the total timings. The petitioner side will get maximum 5 minutes for rebuttal, while the respondent side will get maximum 2 minutes for the sur-rebuttals. The teams are requested not to approach the bench directly. In case of any referral to the exhibit, kindly hand over the same to the court masters. If your lordships permit, can we take the timings from the teams? Much obliged, your lordships. The court is in session now. Option 6, will you approach the dais? The court is in session now. Thompson seeks permission to approach the dais. Much obliged.
Council seeks permission to address the bench's lordship and your honor. Much obliged, your lordship. Present council stands on behalf of appellant and has approached the Honorable High Court under section 482 of CRPC. If the bench is satisfied, if the bench is well versed with the facts of the case, council seeks permission to proceed with issue raised in this case. Much obliged, your lordship. In this case, in all, three issues are raised. First is whether sexual harassment was committed by Rajneesh. Second is whether Patel is liable for non-initiation of police complaint and whether the formation of internal complaint committee is constitutional. And third issue is whether Rajneesh is liable for defamation under section 499 of IPC. Issue number 1 and 3 will be taken by standing counsel and issue number 2 will be taken by my co-counsel. Counsel seeks permission to proceed with issue number 1. Much obliged, your lordship. It is most humbly submitted before the honorable court that Rajneesh is liable for sexual harassment. Your lordship, under section 2, clause N, subclause 1, it explains about physical contact and advances. At casino, dance at this cafe, leaning on her shoulder and sleeping in her lap. All these are the actions of sexual intimacy. Generally, in long journey, we may fall asleep, but no one leans on a shoulder. Rarest of the rare case, a person leans on a shoulder, but how could someone sleep in one's lap without intending to do so? Your Honor, it is clearly stated in the factual matrix that Apsara tried to find a safe seat within a back seat. It means she was sitting too close to window. Counsel seeks permission to submit the exhibit. Your Lordship, in fact...
Counsel, this happened in a territory which is not in India.
Yes, Your Lordship.
Then,
Your Lordship...
why should we interfere?
Your Lordship, it's true that it's not happened in the territory which is outside India, but Apsara and Rajneesh both are employees of a company, both are employees of a hotel, Majorika D, which is established in India. Apsara went in Nepal to handle a branch, Majorika Yeti, on their recommendation. She was originally employed in India, but she had to visit Nepal as per his contract. India in emergency conditions. That's why we are following. That's why we are implementing Indian law in that case.
No, how the offence is made out in India? How the offence is in India?
Your Lordship, offence is not in India. It's outside the territory. But these two employees are of Indian hotel, and they went there for the work of branch which is established in India and it was in the fulfillment of the order of their senior. That's why we have to interfere in that matter. Your Lordship, we have in the factual matter, the word uses Rajneesh booked a taxi. As per a survey, the smallest model of car which is used as a taxi in Nepal is Alto. We have submitted the photograph of the rear seat, and on the back side we have mentioned the dimensions of seat. It clearly states that it has sufficient space so that two persons can sit easily. When there is a sufficient space for two people, then how a person can lean on a shoulder and slip into someone else's lap without intending to do so? Counsel seeks reliance on the case of Apparel Export Promotion Council versus A.K. Chopra. It's mentioned on the page number 14 of memorial and mentioned as A1 in compendium. In this case, Honorable Supreme Court has overruled the judgment of High Court, in which High Court states that sitting too close doesn't constitute the offense of sexual harassment. But the Honorable Supreme Court Even assuming there had not been a physical contact, the contact was still unlawful because the offender had made objectionable overturns with sexual overtones. Counsel also seek reliance on the case of Satyani Sharma versus National Insurance Company mentioned on page number 14 of the memorial, in which Honorable Delhi High Court held that sexual harassment need not to be physical in nature and can also include verbal or non-verbal conduct such as unwelcome advances, comments, and gestures. Council also seeks reliance on the Article 2 of Vishakha judgment mentioned at page number 23 of memorial and mentioned at page number 14 of memorial and mentioned as A23 in compendium. In this article, it was held that attempted physical contact constitutes sexual harassment. It is not necessary for there to have an actual physical contact. Further, from the very beginning, Rajneesh was trying to come closer to Apsara. Apsara doubted her gut feeling so that she will not harass an innocent person. But by analyzing the series of events, we realized that he was intending to sexually harass her from the very beginning. Earlier at casino and at this cafe, he tried to touch her inappropriately. But when he failed to do so, he tried to gain trust by usual outing and dinners. After that, he proposed a Pokhara trip to Apsara. Initially, she was hesitant, but later on, she agreed for the same, just for the interview purpose. Your Honor, in car, Rajneesh started showing his true colors. He started leaning on her shoulder and leaning on her lap. Later, she got to know Rajneesh had booked a single room on the name of Mr. and Mrs. Rajneesh Bain. All these actions and series of events are considered as sexual harassment. Under the section 2, clause N, subclause 5 of the Posh Act, it states any other unwelcome physical, verbal or non-verbal conduct of sexual nature, whether directly or indirectly, shall consider as sexual harassment. His intention was nullified in booking single room. From his act, it was proved when immediately next day he started behaving strangely. When his sexual intent was not fulfilled at that day, he suddenly changed his behavior and started creating a hostile working environment for Apsara under section 3, clause 2, subclause 4 and under section 3, clause 2, subclause 5 of the Posh Act. Counsel seeks reliance on the case of Deputy General of Police versus S. Satyamurthy, mentioned on page number 18 of memorial and mentioned as A4 in compendium. In this case, it was held by the Honorable Supreme Court that it is difficult to establish that the accused has uttered the words or made the sound or the gestures, and seldom a woman files a complaint, and often the wrongdoers are left unpunished, even if the complaint is filed, since there is no effective mechanism to monitor and follow up such acts. As per a report of WICCI mentioned on page number 15 of compendium, the 15 of memorial, it states that almost 50% and 55% are women suffer from the physical contact or advances or the inappropriate touching, including pinching, patting, rubbing, or purposefully brushing up against another, at least once at the workplace. Your Honor, of course, the people who face such incidents, 55.2% decided not to file a complaint and exploit their talent and skills to do their best in their employment. Your Lordship, resignation is also punishable under the section 509 and section 354A of IPC. which states about the outraging the modesty of women and sexual harassment. Counsel argues that lack of evidence supporting misconduct against the appellant does not imply that sexual harassment did not occur. If bench is satisfied with issue number 1, counsel seeks permission to proceed with issue number 3. Much obliged. Your Lordship, issue number 3 is whether the offence of defamation committed by Rajneesh under the section 499 of IPC. It is most humbly submitted before the Honourable Court that it is alleged that Rajneesh is punishable under the section 499 of IPC and he has committed the offence of defamation. Reputation being the driving force behind human behavior must be safeguarded and protected. Every person has right to live with dignity as provided under the Article 21 of Indian Constitution. And to live with dignity, reputation must remain unharmed. Reputation, being a jewel for every person, need to be protected. In the context of defamation law, published does not necessarily mean that the statement was printed in a book, magazine, or posted online. A defamatory statement is published when the defendant says or shows the statement to anyone other than the plaintiff.
Counsel, what was the defamatory statement?
Yes, Your Lordship. On the page number 3, para number 18 of the proposition, Rajneesh gave statement in front of committee that Apsaras enjoyed my company and always looked to spend time with me. Even after the office hours, she went on many intimate dinners with me, even though it was not professionally required. This was a statement by which he insulted, character assassinated her, and defamed her in front of committee as he gave statement on record. The words here used like the intimate, enjoyed my company after the office hours, these harass her and these words defamed her in front of committee and make her uncomfortable. Even that after the proceedings of committee, she always feel uncomfortable to work with her co-employees.
What she said, everything in defense. Whatever he said in defense. Then how it is defamatory?
Your Lordship, no doubt, he said this in defense. But if a person has freedom of speech and expression under Article 19(1), it is also subjected to exceptions mentioned under Article 19(1), Article 19, Clause 2, in which a person can't give a statement which is defamatory for another.
Even if it is truthful.
But Your Lordship, the statement was not truthful. He made the statement that she always looked to spend time with me even after the office hours. I want to bring your attention towards the proposition. There are certain words which are mentioned, like on the first on the para 9 in the proposition, it was said that it was pleasant surprise for her to see Rajneesh, but this pleasant surprise very soonly changed into a nightmare as she went to casino with him, but at casino he tried to touch her inappropriately, and by touching her inappropriately he harassed her. After that, and here the word is specifically mentioned, she escaped a bit. Then how can he give a statement that she is always trying to find an opportunity when she was trying to escape? Then in the next paragraph, para number 11 on the page 2, it was mentioned that when Rajneesh proposed the Pokhara trip, she was hesitant. The word used was hesitant. She agreed just for the sake of interview purpose, for the work purpose. We can't say that she is going for the interview purpose. That means she is trying to look an opportunity to spend time with him. His statement was totally false and And another, when he has booked a room on the name of Mr. and Mrs. Rajneesh Bain, she shifted into the internal suite and locked the room. Rajneesh was the one who was again and again knocking the room and asking her for the tea and other substances. She was the one who refused it. She stayed in the internal suite and slept for an hour. It clearly states that she was not interested in his actions. It means the statement given by Rajneesh was not true. Then again, at the dinner time, he asked for dinner and to play casino. She has to prepare herself to come out and go for the dinner. But anyhow, she managed to go to casino, which clearly states she was not interested in him. She was not looking for the time to spend with him. Again, after that, there are many instances when we see that, like in the taxi, she was sitting too close to window. Then how he can give a statement that she is looking for an opportunity to spend time? He gave the statement that she went to many intimate dinners with him. The word intimate dinner, if we see in journals, is used for a dinner which we can say romantic in nature. What he is giving a statement to the other people that she is interested in him. Even when she was making such clear action that she is not anyhow interested in him, she was avoiding him. She was looking out of the taxi. She was sitting too close to the taxi. She was shifting to the internal suite, locking the door. Then how his statement is truthful?
So, madam, assuming what you are saying is correct, we assume it. What you are saying is absolutely 100% correct. Why have you come to the High Court? Is High Court meant for this purpose? You have come to Delhi High Court.
Yes, Your Lordship.
Why did you go to the magistrate file complaint? Why have you straight away bypassed the process of law?
Your Lordship, we have approached the court under the section 482 of the CRPC, which deals with the inherent power of the court. In our case, there is severe breach of the procedure. When the complaint committee was formed, it was not constitutional in nature. It will be covered by my co-counsel in detail. There was breach of process. That's why we have to approach directly to the High Court.
No, you have come here for defamation as well.
No, Your Lordship. Earlier, for the defamation, we went to the Chief Judicial Magistrate. Then the decision was not in our favor. Then we filed an appeal in Session Court. It was will of the High Court that it clubbed both the appeals. Yes, sir. Your Lordship, intention on the part of the accused to harm the reputation, the knowledge, or the reasonable belief that an imputation will harm the reputation of the person concerned is an essential ingredient of an offence under section 499 of IPC. If the language is highly intemperate and disappropriate to the facts, then the position might be different and malice could be inferred. Statement by the Rajneesh that she always looked to spend time after the office hours using the term intimate dinner is defamatory on the part. Rajneesh knows very well he is making a false statement, but he tried to pretend himself innocent and Apsara, a characterless lady. It is not consequently necessary that a person complaining of defamation should show that he actually suffered any harm in reputation, provided the words are prima facie defamatory. The words of Rajneesh using the term intimate dinners, looking to spend time after the office hours, these statements are prima facie defamatory. In the case of Chaman Lal versus State of Punjab, mentioned as A3 in compendium and page number 32 of the memorial, it was held that in order to establish good faith and bona fide intention, it has to be seen where there are reason to accept the version that the accused acted with care and caution, and finally, whether there are preponderance of probability that the accused acted in good faith. In the present case, there was absence of bona fide intention on the part of Rajneesh. Just because Apsara has complained regarding his behavior, which he thought she won't have, owing to her silence silence throughout the trip, and also her complaint regarding the willful humiliation when he told to bring cold drink for her. It was in the retaliation that he made this statement. Your Lordship, the right to reputation is part of right to decent and dignified life, which is an inalienable right. The court in various judgments have recognized the existence of right to reputation as an integral part of one's life. Justice Brown said that the right to the enjoyment of a private reputation unassailed by the malicious lender is of ancient origin and is necessary to human society. A good reputation is an element of personal security and is protected by the constitutional equally with the right to enjoyment of life, liberty and property. Your Lordship.
Madam, the same proposition applies to the Rajneesh also. He also wants dignity of life.
Pardon, Lordship?
Same proposition what you are saying applies to Rajneesh also. He also says the same thing that my privacy has been infringed. This is his allegation. So equality before law.
Yes, Your Lordship.
Then what answer you have to this?
Your Lordship, Apsara was a female. In our Indian society, a female thinks a lot before filing a complaint. She has filed a complaint. Even then,
But she has not thought before filing complaint. She has immediately filed it.
no, Your Lordship, she has taken the time period of 7 days. After that, she filed complaint. She has gone through all that behavior during the during the Pokhara trip and during the workplace of the Kathmandu. Your Lordship, in the case of Vinay Kumar Saxena versus Aam Aadmi Party, mentioned as A22 in compendium and mentioned on the page number 34 of memorial, Honorable Delhi High Court held that Article 19(1)(a), freedom of speech and expression, is not absolute in nature. The same is subject to restriction under Article 19(2), which includes defamations. Your Lordship, hereby Council submit Rajneesh had fulfilled all the essential ingredients of Section 499 of IPC and does not fall under any exception. So he is liable for the same. If the bench is satisfied.
Read the sixth exception. Sixth exception to the provision. Is it not an exception here?
Pardon, Lordship.
Read the next exception.
Your Lordship, sixth exception states merits of public performance. It states it's not defamation to express in good faith any opinion respecting the merits of any performance which its author has submitted to the judgment of the public, or respecting the character of the author so far as character appear in such performance and no further. Your Lordship, that the word uses good faith. On the part of Rajneesh, there is absence of good faith and it's full of malice. He was just character assassinating the Apsara, he was humiliating her, he was mentally harassing her, he was sexually harassing her. That's why the statement given by him in front of internal complaint committee must be constituted as defamation under section 499 of IPC. If the bench is satisfied with issue number 1 and 3, counsel seeks permission to call co-counsel to proceed with issue number 2. Much obliged, Your Lordship.
Council seeks the permission to approach.
The council seeks a permission to proceed with issue.
Yes.
Much obliged, Your Honor. Issue 2. Whether the hotel is liable for the non-initiation of police complaint and whether the internal complaint committee is unconstitutional. Respectfully submitted for the consideration of the Honorable High Court. It is alleged that the hotel in question violated the law by failing to establish a committee and also neglected its duty by not initiating a police complaint. Your Honor, Section 4 of the Prevention of Sexual Harassment of Women at Workplace expressly mentions the composition of internal complaint committee. Clause 2 of the concerned section clearly states that the presiding officer shall be a woman. Even though, Your Honor, all other posts were fulfilled as per the law, but the most important post, that is of the presiding officer, was not fulfilled as per section 4. Your Honor, in the case of Vishakha and others versus State of Rajasthan and others, mentioned as 823 for the compendium and page number 19 of the memorial, the Supreme Court provided for the creation of an appropriate complaint mechanism so as to ensure time-bound treatment of complaints of sexual harassment. Para 7, therefore, stipulates that the complaint committee should be headed by a woman and not less than half of its members should be women, and further, to prevent the possibility of any undue pressure or influence from senior levels, such complaint committee should involve a third party, either an NGO or other body, who is familiar with the issue of sexual harassment. Your Honor, the Act specifically mentions the word shall. The usage of word shall should be seen in a broader sense, Your Honor, while interpreting the question of whether a provision of law that contains the word may or shall is mandatory or directory. The prime rule that should be followed for such interpretation is ascertaining the true intention of the legislature, which is guided by the maxim mens or sentia legis, by considering the entire statute, Your Honor. Your Honor, according to Salmon, as the essence of law lies in the spirit, not in its letter, but letters are the only way in which the intentions are expressed. The words are the external manifestation of the intention that it involves. When there is a possibility of one or more interpretation of statute, the court has to adopt that interpretation which reflects the true intention of the legislature and which can also be considered as the legal meaning of the statutory provision. Your Honor, in Crawford on the construction of statute, at page 516 of that book, it is stated that the question as to whether a statute is mandatory or directory depends upon the intent of the legislature and not upon the language in which that intent is quoted. The meaning and the intention of the legislature must cover, and these are to be ascertained not only from the phraseology of the provision, but also by considering its nature, its design, and the consequence which would follow from construing it in one way or other. Your Honor.
But counsel,
Yes, sir.
there was no woman available as per the effects. There was no woman available. How could a woman be a presiding officer when it's not available?
Your Honor,
There was only one woman who was abroad.
Yes, sir.
Then
Your Honor, it was the if and buts of the respondent that they thought that Ms. Claudia was busy. They had the time to arrange the other staff members from the other countries, but they did not have the time to consult her. It was their if and buts that included the possibility that she might be busy. Agreed, Your Honor, that she has busy schedule, but Your Honor, what is more busy than the issue of sexual harassment? Are the appointments way more important than the issue of sexual harassment? Is the dignity of women not that important that they did not even consult her? The council seeks the permission to consult. In raise of statute, the 7th edition, it was stated that it is the duty of the court to try to get at the real intention of the legislature, and by carefully analyzing the whole scope of statutes or section or a phrase under the consideration. Your Honor, the council seeks reliance on the case of State of Haryana and others versus Raghuveer Dayal, referred to as 820 for the compendium and page 22 for the memorial. It is stated, normally the word shall prima facie ought to be considered mandatory, but it is the function of the court to ascertain the real intention of the legislature by careful examination of the whole scope of statute, the purpose it seeks to serve, and the consequences that would flow from the construction to be placed thereon. Your Honor, the word shall therefore ought to be construed not according to the language with which it is quoted, but the content in which it is used and the purpose it seeks to serve. The council also relies upon in the case of Sri Ram versus State of Maharashtra, mentioned as 824 for the compendium and page 24 of the memorial, the court held
The fundamental rule of interpretation is one of that if the words of the statute are in themselves precise and unambiguous, no more is necessary than to expound those words in natural and ordinary sense. The words themselves in such case best declares the intention of the legislator. Your Honor, in the case of A.V. Purushottam versus N.K. Nagaras, mentioned as A2 for the compendium and page number 22 of the memorial, the High Court held, from the fourth proposition of law, it becomes clear that where the statute uses the word shall, while laying down a duty, it is not conclusive on the question whether it is mandatory or directory provision. In order to find the true character of the legislation, the court has to ascertain the object which the provision of law in question is to subserve and its design and the context, Your Honor, in which it is enacted. If the object of the law is to be defeated by non-compliance with it, it can be regarded as mandatory. Your Honor, a procedural rule ordinarily should not be construed as mandatory. Your Honor, the intention of the legislature to use the word shall before the presiding officer was to make sure that such person chairs the meeting who has the knowledge of sexual harassment, and the complainant would be at a better position to tell all the misconduct that have happened against her. Your Honor, in the present case, by appointing a male as a presiding officer, the intent of the legislature was ignored. Mr. CEO failed to consult Ms. Claudia, the sole senior woman to appellate who was to act as presiding officer. Your Honor, it was his if and buts that included the possibility that she may be busy. There was no communication or effort from his end to express the situation to her. This lapse in communication and coordination is a matter of concern as it represents the deviation from the established protocols and could have led to the erosion of trust among the members or the appellate. And Your Honor, in the present case, there was erosion of trust. Your Honor, when Rajneesh had visited Nepal, we were quite happy that there was someone who had come to help us with the manpower. Your Honor, we were happy, but we never knew that this happiness would turn into a nightmare. And when we had come to committee, had come in front of the committee for justice, the committee gave an unclear verdict. They were not sure whether the sexual harassment had occurred or it had not occurred, Your Honor.
Counsel,
Yes,
all the allegations which were the subject matter of the committee,
Yes, sir.
all the allegations were pertaining to a territory which was foreign to India, which was not in India. Why should the committee go into the offences which are committed outside the territory of India? Where is the territorial jurisdiction?
Your Honor, it is mentioned under section 3 and 4 of IPC specifically mentions the extraterritorial jurisdiction, which states that if there is any crime that has been occurred outside India, the Indian courts have that power, have the power to have the jurisdiction for such cases. And Your Honor, here Apsara had went for the official work of a hotel that was established in India. If the local GM of that chain had not resigned, she would have not gone. Only when the local GM had resigned was there, she was sent for that work. The council seeks permission to proceed. Your Honor, the committee's primary job is to provide a safe environment, hear addresses, and provide justice. In this case, committee's ruling was unclear. They were doubtful as to whether the offence had been committed or not. In the case of State of Kerala versus Hamsa, page 25 of the memorial, it was held that even if the conduct of the accused goes unnoticed by others except by the victim, the conduct will amount to insult to her modesty. The council argues that the lack of evidence supporting the misconduct against appellant does not imply that sexual harassment had not occurred. That was based upon the witness testimony primarily from the taxi driver. Your Honor, Bentham, witness, as Bentham said, are eyes and ears of justice. Hence the importance and primacy of the quality of trial process. Your Honor, the testimony of the main witness was sidelined and a decision was given. The proceedings were not held properly, Your Honor. Your Honor, also in some institutions there is a process of elections. That via elections, the complaint committee is established. The councillor suggests that this is an alternative as to express the unbiasedness. This democratic process would involve the participation of all the members of the organization and enhance the legitimacy of the committee, thereby instilling the confidence in the victims to report the instances of sexual harassment against the fellow employees. Your Honor, once elected, the name and the contact information of the committee member would be displayed. Your Honor, according to Mr. Yuan, it would have been unprofessional to burden Miss Claudia, the only female superior with this responsibility. Instead, he could have initiated an election process. He could have gone via this way. But what he did was he chose to arbitrarily decide himself as a presiding officer because it was his offense was that included that she might be with him. Your Honor, Your Lordship, we are here to seek justice. Some may perceive us as unreasonable for turning to the court due to the dissatisfaction with the previous decision. However, Your Honor, when a woman endures repeated instances of sexual harassment and is subjected to unbearable languages, seeking reports from relevant authority is a natural course of action. And when those avenues fail to deliver the justice, the only recourse that is left is to seek redress through the courts. Your Honor, the council argues that the hotel was obliged to file a police complaint against Rajneesh. Since the appellant was an employee of Majorca D, the hotel, it was a duty of the hotel to report the incident to police. The appellant had faced unwanted behavior from the accused while performing her job, which falls under the purview of the hotel's responsibility. Your Honor, the hotel is a chain of a globally recognized La Majorca that is operating in 22 countries worldwide. The hotel, being involved in a police matter, had the potential to adversely impact its reputation as well as that of La Majorca. Hotel is a legal entity, Your Honor. That means the hotel has the right to be sued and to sue for defamation. Your Lordship, defamation is an offence that is closely linked with reputation. By refraining from initiating a police complaint, the hotel aimed to protect itself from any harm that could be caused due to its involvement.
Why you directly don't go to the police? Why do you want the direction to the committee to lodge a complaint? You can straight away approach the police or court.
Your Honor, because the POSH Act explicitly mentions Section 19 that has two clauses, Section G and Section H, that states that it is the duty of the employer. Section G specifically talks that it is the duty if the griever desires to do so, and
Yes,
Section 19 clause H states that the employer can initiate a police complaint. So, Your Honor, here if we did not desire, we were not in that state of mind that we could go and approach and tell them that we have to file a police complaint as well. We had complained regarding sexual harassment, and we thought that it was enough in order to constitute the other duties of the employer. Your Honor, but we never knew that the hotel would violate this duty as well. Your Honor, they had violated one of the main provisions, that is of the presiding officer. Yet we were quiet because we have this slightest of hope that justice may prevail, Your Honor. It might prevail because of the fact that Mr. Yuan was that thoughtful that if there is no person of no employer of junior rank should preside over the meeting. But Your Honor, when we got to know that even that slightest hope was shattered, and even at this hope that this duty of employer was also something that we had to tell them. Your Honor, they are a global chain. Your Honor, the council believes that they have legal representatives in their hotel, in their company. Every company has a legal department. The legal department could have told them about their duty. They were not performing their duty because they knew that if they perform their duty, the police complaint would have initiated, their name would have been there in the.
So then what relief do you want from this court?
Your Honor, the relief that we want is the reconstitution of the ICC, and that the hotel was liable for the non-initiation of police complaint, and that there was defamation that was done by Rajneesh, and also regarding the sexual harassment that it had occurred. Basically, we want that the reports of the ICC should be quashed, and we approach the High Court regarding the same. The council seeks the permission to proceed further. Your Honor, as per respondent 2, as the council has already stated, there was no complaint made regarding the initiation of police complaint. However, it was the responsibility of the company to ensure that the police complaint was initiated. The appellant was working for the company, and it was due to their lack of effective management and distorted actions of the appellant that and their distorted actions that the appellant had to travel to Nepal, where she had to endure such unwelcome behavior from respondent. It was the duty of the company or the institution to provide a non-hostile environment, Your Honor, and in the present case, they had failed to provide so. Your Honor, in the case of Dr. Sohail Malik versus Union of India, mentioned as 821 for the compendium and page number 12 for memorial, the Honorable High Court observed several objectives of the POSH Act, and it stated that it's not only limited to ensuring women's right to equality, life and liberty, that it was not only violated or compromised, also providing a secure and friendly work environment, equality in environment, ensuring women are treated with due respect, decency and dignity at workplace. Equalizing of sexes in every aspect of life is therefore a constitutional imperative, Your Honor. The working environment is required to be safe and secure for women as it is for men. Even an apprehension by a woman that her safety might be compromised or endangered in the workplace is therefore abhorrent to our constitutional effort. And when this issue was raised before CEO, being company's representative, he should have himself or should have guided only the appellant regarding the non-initiation of complaint. Since, Your Honor, we were already quite distressed and shattered by the judgment of the by the decision of the.
All right. Since you are 2 minutes left, suppose we set aside this order
Yes, Your Honor.
of committee and we reconstitute the committee.
Yes, Your Honor.
Then are you optimistic that then again, because it's their hotel, so are you so optimistic that you will get justice from them?
Yes, Your Honor, we are optimistic enough because what we know is that earlier there were lacunas, but this time when the High Court quashes it, sets it aside, then justice would definitely prevail. If Your Honor is well versed with the issue, the council will proceed. The council would proceed with the prayer. Much obliged. Wherefore, in the radiance of facts, issues raised, contention progress, and authority cited, the council for appellant modestly implores that the Honorable High Court may be pleased to: first, the charge of sexual harassment was not malicious; second, the committee formed was not in accordance with the law; third, the hotel was under the obligation to initiate a police complaint; fourth, that there was defamation done by the judge. Pass any such order, judgment, or direction that the Honorable High Court deems fit in the best interest of justice, equity, and good conscience. For this act of reverence, the council for appellant, as in duty bound, shall forever pray. The council rests your Reading to the bench. If it may please to the Honorable Bench, may the Council address the bench as an Honorable Bench for the convenience of the proceedings. The Council is appearing before the Honorable Court in the matter of Afra Lingam versus Rajneesh and others, on behalf of respondent under section 482 of CR. If the council will be dealing with the first and the second issue and will be speaking for 22 minutes, and the co-counsel will be dealing with the third and the fourth issue and will be speaking for 21 minutes, respectfully reserving 2 minutes for the certain issues. If your lordship is well versed with the facts, may the council proceed with the argument. Much obliged. If your honorable bench, the first issue, whether the appeal is maintainable. Here, the council will submit for under two grounds. First, the appeal is not maintainable as appeal is only maintainable against the order or judgment of the court. Here in the particular case scenario, there is no court which is giving the judgment. In the present case scenario, the ICC, the Internal Complaints Committee, which was formed under the POSH Act, it is not a court, but it is just a committee which was formed.
No, madam, you have come under 482. They have come under 482. So then, is it inherent powers?
Your honorable bench, council agrees that there is an inherent power. But in the second ground, council will be countering with that also. That in the second ground, it is mentioned that there are certain alternative and effective remedies which are present in the POSH Act. Therefore, if certain acts give certain rights and obligations to certain persons, therefore it also creates certain procedure to be followed to uphold those rights. In the present case, it has been mentioned under section 18 that they have provided with the alternative and effective remedy, under which it is mentioned under section 18 of the POSH Act. It has provided that if there are certain provisions and recommendations, if person is not satisfied with those, then they can approach to the tribunal under section 18 of the POSH Act. Therefore, it is also one of the things which the honorable bench should notice, that if alternative and effective remedies should be first exhausted.
No, but when on the face of it, it can be seen that there is a violation of law. The woman was not presiding over. Then on the face of it, it's there. Then why to relegate them to some alternative? It's on the face of it there's a violation. Why you did not constitute a committee held by women, which is a mandatory to be signed on?
Council understands from
What
where.
is the answer to that? Why have you not constituted a committee held by women once the law says so?
Council understands from where the concern is arising from the honorable bench.
Then
And council will deal with this issue in the issue number 2 in the further course of argument. But for the convenience of the bench, it would like to summarize the main contention that the whole inquiry went on. She trusted the procedure then, and she did not contend with the inquiry.
there is no estoppel against law.
Your
There is
honorable.
no estoppel against statute.
Your honorable bench, if she has a problem with the whole committee that it was not constituted in
There is no estoppel. Once the statute provides for a particular mandatory provisions, the condition precedent sine qua non. Nobody can say that there is the doctrine of acquiescence, the doctrine of waiver will not apply.
If you let me please, the honorable bench, may the council deal it in the issue 2 and will summarize there, and we would want to deal with the first thing, that if an alternate remedy is mentioned and there is a breach of intercourse hierarchy, it should come within that the tribunal should be followed first and should not invoke the special jurisdiction under the High Court. Council will be dealing and would try to satisfy the honorable bench on the issue 2, that the Internal Complaints Committee was constituted in accordance with law or not. If the honorable bench is satisfied with the issue 1 contention, may the
Yes.
council proceed with issue 2?
Yes, yes, continue.
Issue 2, under which it is whether the Internal Complaints Committee was formed in accordance with the law. Council humbly submits on behalf of the respondent that the committee was formed in accordance with the law, which council will be establishing under 2 grounds. First, the purpose of interpretation of section 4, which includes that substantive law should take precedence over the procedural law. And second, the respondent aimed to provide the instant redressal to the appellant over here. Here, the council for the first ground submits
that the principle of purposive interpretation or purposive construction is based on the understanding that courts should attach the meaning to the provision which serve the purpose behind the which serve the purpose of the procedure. Therefore, court should attach the meaning of the intention which has to be served in the present case procedure which is provided under the statute. Therefore, the council relied on a case, Chalet Tehriwan versus Mohan Balkrishna, where it was for which the Honorable Bench may refer to the companion page number 23, which refers that statutory interpretation of provision is never static, but it is always dynamic. Therefore, council would like to submit under this the intention of the POSH Act to provide women head is summarized under 2 points by the council. First, the intention under the POSH Act to provide the women head to the committee is to adhere to or to form that there is a safe and a comfortable space which is provided to the women so that she can feel safe to file a complaint. Second intention was to provide that the contention of the aggrieved women should be understood and should be provided the redressal in that manner, and the verdict should be in the favor of the women. Here, in the present case scenario, the as per the as it is mentioned that Juan Cotto has provided that safe space. As mentioned in the para 11, that upon returning, she instantly came to him and filed the complaint, and therefore. In the further moot proposition, it was mentioned that in the further it is mentioned that he tried to constitute the committee and he has given the favored verdict. He was the only one in the committee who has given the verdict in the favor of the aggrieved women. Therefore, this shows that he understands and empathizes with the women, and he tried to fulfill all the intention of the POSH Act. Therefore, as the council submits that the intention was fulfilled by the presiding officer, and further it was submitted that in the present case it was seen that substantive law was given precedence over the procedural law. Therefore, it was this shows the intention of the presiding officer, who was Juan Boto, the chairperson. He has the intention to provide the instant redressal to the aggrieved women so that to uphold and restore the position of the women in the workplace. And for that, council relied on a case, relied on a case, the state of Punjab versus Shamlal Murari, for which the Honorable Bench referred to the compendium, page number 26. It has been given, while considering the need of complying with the procedural provision observed as under, we must always remember that processual law is not to be a tyrant, but a servant, not an obstruction, but an aid to justice. It has been wisely observed that procedural prescriptions are handmaid and not the mistress, a lubricant, not a resistant in the administration of justice. Herefore, council submits, in the present case, it has been seen that he wanted to provide the instant redressal, and he tried to fulfill all other requirements. The only requirement which was...
Please rise. We have the attendance of Honorable Mr. Justice C.T. Ravi Kumar, Judge, Supreme Court of India. Please be seated. His Lordship is here to attend the proceeding of this final round.
Yes, continue.
May the council proceed?
Yes, continue.
As it has been seen in the present case, the respondent organization wanted to provide the instant redressal to the aggrieved women. He understands the gravity of the situation. Therefore, he tried as swiftly as possible to constitute the committee in the present case scenario, which was given in para number 11 of the Moot proposition, that he fulfilled all the criteria, and this was also given that he fulfilled all other criteria under clarifications 19, which is present in the compendium, page number 5.
that all the criteria was fulfilled. Therefore,
So, madam, counsel, you are laying more emphasis on the difference between procedural law and substantive law. So, is it not a substantive law that what is the meaning of substantive law? When the right is vested or created or lost. So, if a committee is to be headed by a woman, will it not be a part of the substantive law?
Your Honorable Bench, as it is being provided under the procedural law, therefore that's why council is submitting that a substantive law should take precedence. Here, the substantive law means that the more greater justice which has to be provided, which is related to the rights of the person. Then,
That Apsara, she had a right to be heard by a committee headed by a woman, which is a sine qua non provision. So then you have deprived her.
council understand, but in the present case, as there was he wanted to adhere to all the criteria. He adhered, and in the present case, the inquiry which was taken place was also according to the Posh Act. He adhered to the cases. He adhered to the requirements. The only thing which he failed because there was an absence of senior women employed. She is the most senior woman which is present here, and therefore it was not possible for him in the very instant.
So therefore you have violated the Visakha guidelines as well. Not only the mandatory provisions of law, you have violated the judgment of Supreme Court. So then why we should not quash it and we reconstitute it?
Your Honorable Bench, Council understands the concern, but would beg to differ as Council earlier pleaded that the whole intention of the Act, there was certain intention to make it a women-centric law. And therefore, here the intention to provide the women as a head of the committee, that she can understand more, she can empathize more with the women, and she can understand the graver part that which is happening with the women here in the particular case scenario of the harassment. Here, as a earlier proof, and here again for the convenience of the bench, summarizing that even though there was no women who was heading the committee, all other requirements were fulfilled. All other members were present according to the requirements of the Posh Act. And therefore, according to the Posh Act, there was a requirement to provide 50% women employed in the committee. Therefore, there was presence of women in the committee. The only thing which he was failed was women committee head.
When all the conditions which are conditions precedent and sine qua non, and they are to be adhered to, then you can't come along and say that one of the conditions was violated, which was notwithstanding the fact it was sine qua non condition. So why you have proceeded with the inquiry which was against the spirit of law and the basic provision of law? And for that matter, you are arguing that intention is to be seen. No, the doctrine of little construction will apply. You can't say that no, we have to see the intention. You have to see the wording used in the legislation. No?
Council understands the concern of the Honorable Bench and therefore would beg to differ, as in the present case, the only senior employee was present was Claudia Bissoul. Therefore, she was the one.
No, but you tell me what prejudice will be caused to you if we set aside that order and you reconstitute it again. What is your problem, matter? Are we finished? Is it not in your interest as well? You are a big hotel. You are having 22 countries. You have a presence. Your reputation is also at stake. So we quash it and reconstitute it. That's all.
The council understands this, but once if this case would be allowed and there was a whole judgment against that the hotel failed to comply with the provision. This was also against the image of the hotel. But hotel has the intention to provide the instant redressal. This should also be taken in the by the Honorable Bench. The intention of the respondent organization. They had nothing against the aggrieved women, but the only thing which they were concerned with to provide the instant redressal to her. And therefore the council feels that there should be a purposive interpretation and should see the intention of the respondent organization. As they wanted to provide the redressal, they don't have anything against for the aggrieved women. They were the one who wanted to uphold her position, and the only thing which he failed is to women head. And the whole inquiry was conducted by the employee who are under the requirements of the Posh. They were the one. Inquiry was also taken place according to the Posh Act. They were the one who has cross-examined Rajneesh,
cross-examined the taxi driver, and they came to the judgment that that there was no sexual harassment against the will of the petition against the appellant, and it was not under the workplace. Therefore, this should also not be looked aside. If one condition was not fulfilled, other conditions were met, and if that conditions were met, the whole inquiry was taken place according to that. Therefore, and it should also be taken in consideration that Juan Goto was the one who was presiding officer. He has given the favored verdict with the agreed women. He understands the whole grave matter of the justice, and he was empathetic towards the women, towards the agreed women. He has nothing to have in a contention. It was also mentioned in the Moot Prop para number 11 that he has a respect towards Apsara. Therefore, he wants to provide the redressal. He adhered to everything. The only thing was not present was the committee head. The committee head was busy with various other engagements. There was 22 other hotel chains which was present the whole other world, other parts of the world. Therefore, it is not easy to address for her to come to the particular chain and address the matter instantly. Therefore, here the whole intention of the respondent organization to comply with this and to went ahead and preside over the committee is to provide the justice to the women. If therefore another contention arises for her, so she has certain doors open so that she can contend. The most important contention of the respondent organization over here, why the whole inquiry was not conducted by Apsara, and why she has not contended, and why she took part in the inquiry.
No. There is no estoppel against law. Can there be an estoppel against statute? I'm telling you again. So will the doctrine of acquiescence, doctrine of waiver apply here? When there is a flagrant violation of the mandatory, there can be no estoppel against law.
Council understands the concern, and it is by the honorable bench that there was no stop. But while she was sleeping on her right side, she was a part of the inquiry. Doesn't she know that there was a male presiding officer while the whole inquiry was starting and was taking place? And it was specifically mentioned in the paragraph. She went on tirade after the whole verdict was came. She went on tirade because verdict was against her. If it was in her favor, she might not have the problem. Therefore, respondent organization wants and had fulfilled all the criteria, and they were empathetic towards the aggrieved women, wanted to address the matter as instantly as possible, and wanted to provide the justice, and therefore they taken the part. Therefore, they had taken the procedural, not the strict compliance of the procedural law, and went towards the greater justice of the aggrieved women in the present case. Therefore, the council humbly pleads the honorable bench to understand the concern of the respondent organization, and please give the council request to give the verdict accordingly, that the intention should be taken into the consideration, and the whole act of the respondent organization that they wanted to fulfill all the criteria, and they went to that level that they have fulfilled all the criteria. The only thing which was not met was the women met, and which might have been followed if it was under the ambit and under the capacity of the respondent organization to fulfill that. In the present case, it was not instantly possible to adhere to that, because the only senior women employee was outside India, and she was the Indian GM. Therefore, no senior women employee was present. The only senior to the women here was Juan Goto. Therefore, he presided over the committee. The council pleads the honorable bench to look into the matter and please see to the intention of the respondent organization, and please verdict accordingly.
So you want a verdict accordingly. You don't want the petition to be dismissed.
For the issue 2, council was submitting, and for the issue 1, council submit and please. And if the honorable bench is not satisfied, council would like to satisfy more on that there is an alternative remedy and there was an effective remedy. If an effective and alternative remedy was present to uphold certain persons' rights, that should be followed and that should be taken into consideration first. And it should not invoke a special jurisdiction under the Special Act.
Why not when there is an ex officio violation of a mandatory provision of law? Why alternate remedy?
As per various judgments and precedents, it was held that
Alternate remedy is only one of the procedure which the court should follow, but it's not a straight jacket formula. So once it is ex officio, on the face of it, it's bad.
counsel understand, and therefore in the present case, counsel would like to submit that there should be an exhaustion. If a certain remedy is created, it is for to lessen the burden of the High Court. High Court cannot deal with every matter which is coming. Therefore, that is why it has created certain courts at the tribunals, at the sessions, at the magistrate level to deal with the matter, and the council pleads that would provide an instant justice by invoking the jurisdiction under the High Court. Therefore, council pleads that if certain provision was created that the exhaustion of alternative remedy should be done, then therefore council pleads that the exhaustion should have to be done by and this was only given by the judgments of the Supreme Court and the High Court, that exhaustion of alternate remedy is a required procedure which has to be followed. Therefore, council would also like to submit a case. The case is on companion page number 17. Smita Arora versus Chief Executive Officer, under which council would summarize that it is regarding the quashing of the ICC report. Therefore, court held that if there is any matter regarding the quashing of the reports of ICC or any other thing regarding the ICC matter or the Posh statute matter, then that should be a challenge before the appropriate forum first. Therefore, council submits that the alternative and effective remedy is actually an effective remedy which has to be followed. Council submits that the appeal in the present case is not maintainable under the issue 1, and for the issue 2, council pleads the honorable bench to please look into the matter accordingly and provide the verdict that the intention of the respondent organization was to deal with and provide the redressal to the aggrieved women, and they don't have anything against the aggrieved women. Council would like to just wrap up and summarize the issue. Already summarized the issue, and if the bench is satisfied, may the council call the co-counsel to address the issue 3 and 4.
The council seeks permission to approach the dais. Once open. Greetings to the honorable bench. May it please be known, this is Council 2 on behalf of the respondents who rises to continue submissions on issue 3 and 4. Your honorable bench, for the third issue, which is whether the hotel was under an obligation to initiate a police complaint, the respondent humbly submits two strong arguments in this regard. Firstly, Section 11(1) of the POSH Act is not applicable, as no prima facie case is established to refer the complaint to the police. Secondly, as per Section 19H of the POSH Act, it is the duty of the employer to refer the case of sexual harassment to the police when the victim makes the request. In relation to the first submission, if the bench may refer to page number 99 of the compendium, Section 11(1) states that, subject to the provisions of Section 10, which talks about conciliation, the internal committee or the local committee, as the case may be, shall, where the respondent is an employee, proceed to make inquiry into the complaint in accordance with the provisions of the service rules applicable to the respondent, and when no such rules exist, in such manner as may be prescribed, or in case of a domestic worker, the local committee shall, if prima facie case exists, forward the complaint to the police. It is very clearly stated in this provision that the internal complaints committee may only refer the case to the police if a prima facie case exists against the respondent. The case against Rajneesh for sexual harassment did not establish a prima facie instance of guilt, as he was found not guilty after due process and examination of evidence and witnesses by the ICC. Further, the petitioner's decision to continue with the trip to Pokhara with Rajneesh and a failure to raise objections or denying going to outings with him indicates clear consent to spending time with him even after the alleged incidents of sexual harassment. Your honorable bench, The council does not believe that any woman in this country would ever want to stay close to her perpetrators and avoid it at all costs. Apsara, being the Indian GM of such a reputed hotel chain, was a very independent woman. If she had any problems, if she was facing such instances, such severe instances of sexual harassment on the hands of Rajneesh, she could have contacted anyone from the hotel and could have sought some kind of help from the hotel. She still chose to go out with him on various occasions which are not even, which don't even fall under the ambit of the workplace or ambit of the work authorized to her. Furthermore, in Shri Devdulal Mehti versus National Insurance Company Limited, it was specified that the IC should apply its mind to determine whether the complaint relates to sexual harassment and whether the incident has happened at workplace. If the Honorable Bench may refer to Moot paragraph 3, it is very clearly mentioned over there that according to the petitioner's duties and responsibilities at Majorca D, that is the hotel, she was authorized to only attend conferences, team dinners, and other official events. Going out to dinners and casino do not fall under any of these categories. The dinners were also not team dinners as they were privately between Rajneesh and Apsara only. Therefore, based on the evidence presented, it can be concluded that there is no sufficient basis to establish a prima facie case of sexual harassment at workplace in this scenario, hence no onus lies against the hotel to file such a complaint to police. Moving forward with the second submission, the council humbly pleads that according to the duties of the employer enumerated under Section 19 of the POSH Act, Section 19G states that every employer shall provide assistance to the woman if she chooses to file a complaint, and 19H states that employer must pause to initiate action under the IPC or any other law against the perpetrator, or if the aggrieved woman so desires, where the perpetrator is not an employee in the workplace at which incident of sexual harassment took place. Also, in the case of Gwalior Rayon Silk Manufacturing Company Limited versus Custodian of Vested Forest, the Supreme Court reminisced that in seeking legislative intention, judges not only listen to the voice of the legislature, but also listen attentively to what the legislature does not say. The intent behind the statute is very clear to everyone over here, that every woman with to provide everyone with a safe, secure, and dignified working environment. Your Honorable Bench, the social and cultural background prevailing in this nation is that any woman in normal circumstances would not prefer such a complaint of sexual harassment against any person because of what it brings along with it. It is a grave accusation. Additionally, in India, women already experience gender-based discrimination and harassment and are hesitant to contact the police for fear of societal retaliation, social stigma if their identities are revealed, and even low conviction rates. Therefore, it is basic general rule of law that the consent and the authority of the woman is required over here to file a complaint on her behalf. What if the woman did not consent to it? Because nowhere in the facts it is mentioned that Apsara wanted or had the intention of filing a police complaint against Rajneesh. The only thing she did was approach Man Photo for filing a complaint under POSH and not a police complaint. Therefore, it cannot be inferred that she had an intention of filing a police complaint. Therefore, no duty as such falls upon the employer or the ICC to file a complaint on her behalf. It becomes evident that the liability of the employer to initiate a police complaint under the Act is contingent upon the aggrieved woman's explicit request to do so, and in the absence of any such request, the employer bears no liability under any section of the POSH Act. If the bench is satisfied with the submissions regarding the third issue, may the council move on to the fourth issue?
So far as her request is concerned, now they have argued just now that now the request can be considered. Now you do it. Now they are making a request that the police complaint be registered.
Your Honorable Bench, if the petitioner is contending right now,
she has made a request in the court now, in the High Court. So consider her request now.
The respondent may consider the request right now, but their contention was they were bringing a case against us for non-initiation of the complaint. The respondent is justifying that we were not obligated to do it unless they asked us to. Now, if the petitioner has consented to it, the respondent would definitely file a police complaint on her behalf. But the contention was different from the petitioner's side. May the council move on to the fourth issue? Much obliged. Your Honourable Bench, for the fourth issue, which is whether the statements made by the respondent, that is Rajneesh, during the hearing in front of the committee constitutes criminal defamation under section 499 of the IPC, the petitioner submits three arguments in this regard. Firstly, there was no intention to harm the reputation of the petitioner. Secondly, the statement falls under the ninth exception under section 499 of the IPC. And lastly, there is lack of evidence on part of petitioner. In relation to the first submission, the respondent submits that there was no actual malice on part of the respondent, which is one of the essential ingredients to constitute the offence of criminal defamation. Regarding the definition of defamation, it is given that the imputation must have been made with the intent, knowledge, or belief that it will harm the reputation of the person concerned. In the landmark judgment of R. Rajgopal versus State of Madras, the Supreme Court applied the doctrine of actual malice. The rule of actual malice states that liability will be attracted only when it can be shown that the statement was made with the knowledge that it was false or with reckless disregard for whether it was false or not. It is humbly submitted that the respondent's statement to the committee was based on his perception of events and the actual interaction between him and the petitioner. The petitioner did not explicitly object to the respondent's outing plans. She did go to dinners with him as well as to the discos and casinos, which does not fall under her professional obligation or course of employment. He did not harbor any ill will or malice towards her, and his intention was only to defend himself against the allegations while providing his honest account of the events. There was no deliberate intent to spread any kind of falsehood or misinformation. There is no evidence to suggest that he acted recklessly or with disregard for the truthfulness of his statement as well. For the words used in the statement spoken by Rajneesh, that is, she enjoyed my company and was very much willing to go out with me. It is very true according to the facts of the case. She did enjoy his company.
No, he also used the word intimate.
Intimate.
So then, is it not Paxi defamatory? Before a committee, you are saying that she wanted to be intimate with me. So is it not per se on the face of it defamatory?
Your Honourable Bench, the general meaning of the word intimate is considered to be, it is generally interpreted as being very friendly or very close. It cannot be prima facie misconstrued as anything, meaning something negative in any sense.
When the offence of sexual harassment is under consideration, then there can be no second meaning. This is the only inference which can be drawn.
Your Honourable Bench, that according to Rajneesh, what Rajneesh's intention was here was to not defame the woman by stating that the dinners between them were intimate. As they were the only two people present over there, it could have meant that it was a very private thing to them. It could have meant very friendly or very private or very close in that manner. But it was misconstrued as meaning something negative according to the petitioner. And also his statement included the word that even if it was not professionally required, which is also very true because all the dinners and outings did not fall under the ambit of the workplace or the professional obligation of the woman in this case. Moreover, the respondent humbly pleads that there was no actual harm to the reputation of the petitioner. Explanation 4, which is given on page 108 of the compendium, it talks about that the reputation of a person is harmed when the act injures the moral or intellectual character of the person or lowers his credit or character in respect of his caste or calling. In Anand Rao Balkrishna Ravnikar versus Emperor, it was held that it is not sufficient for a complainant merely to say that the allegations he complains of have harmed or are likely to harm or were intended to harm his reputation in the estimation of others. He must prove this before he can obtain a conviction. It is not sufficient for a complainant merely to assert that the allegations against him have caused him annoyance, harassment, or mental worry. It is also not sufficient to raise a presumption that such imputation may lower him or may lower his morale in front of others. These are matters that must be proved. It is submitted that there is a lack of tangible impact on Apsara's reputation. Her devastation without any genuine harm to her character cannot be the criteria to convict the respondent. Nothing in the statement made by the respondent could have created a negative impact on the reputation of the petitioner, as it was only the narration of true events. Furthermore, the absence of formal objections to spending time with respondent suggests a level of tacit acceptance or willingness on the part of the petitioner. It is plausible that the respondent generally believed this statement to be true. Therefore, the respondent concludes that there was a lack of intent to harm the petitioner's reputation and the respondent is innocent in the case. Your Honorable Bench, although the case is not made out against the respondent as the ingredients of defamation have not been fulfilled, nevertheless, the respondent would be moving forward with the second submission, that is, the statement still falls under the 9th exception of section 499 of IPC. The 9th exception under 499 states that it is not defamation to make an imputation on the character of another, provided that the imputation be made firstly in good faith and secondly for the protection of the interest of the person making it or of any other person or for the public good. Firstly, it is submitted in Harbhajan Singh versus State of Punjab. The Supreme Court held that in deciding whether an accused acted in good faith under the 9th exception, it is not possible to lay down any rigid rule or test. It would be a question to be considered on the facts and circumstances of a case. It is submitted that the respondent presented his accounts based on his genuine belief in its accuracy without disregarding the potential consequences of his word. While the petitioner may have perceived their interaction differently, respondent believed his accounts to be accurate and representing the nature of the relationship. And nature of the relationship here can be interpreted as being friendly or very close or very private in nature. He provided his perspective in good faith with care and caution, aiming to offer a comprehensive understanding of the events with utmost while defending himself against the accusations. Secondly, it is submitted that in the case of Kanwar Lal versus State of Punjab, it was held that even if good faith be taken to have been established, the imputation has to be made for the protection of the interests of the person making it. Rajneesh made this statement in response to the serious allegations of sexual harassment and humiliation leveled against him to defend himself against his allegations and safeguard his professional reputation. The allegations pose a significant threat to his reputation and career prospects. In the absence of a robust defense, his career could have suffered irreparable harm in this case. Therefore, his statement can be viewed as a legitimate exercise of his right to protect his own interests within the bounds of law. If the bench is on the same page with me. Moving forward to the third and the last submission, the respondent humbly pleads that the onus to prove guilt in a criminal case lies on the petitioner. The burden of proof rests with the prosecution to establish beyond a reasonable doubt that the accused committed the offence of defamation. Until such proof is provided, the accused is presumed to be innocent. If the bench may refer to page 72 of the compendium, in the case of Puran versus State of Punjab, the Supreme Court held that the High Court has full power to review the evidence upon which an order of acquittal is founded. Yet, the presumption of innocence of the accused being further reinforced by his acquittal by the trial court, the findings of that court, which had the advantage of seeing the witnesses and hearing their evidence, can be reversed only for very substantial and compelling reasons. It was therefore submitted that the respondent's previous acquittal, the bench may refer to page 21, it implies that he was found not guilty of the charges brought against him in that particular case, as the case was earlier taken to the judicial magistrate and the judicial magistrate had already acquitted the respondent. Presumption of innocence in the current matter as well until proven otherwise. The circumstances surrounding the case were thoroughly examined and the evidence presented did not establish his guilt beyond a reasonable doubt. It prompts question about whether the allegations are based on substantive evidence or if there are other motives driving the accusations by the petitioner.
Madam, here you are under 482. They are under 482. All these arguments will suffice only when the trial starts. So we prosecute you, and then whatever onus of proof is on them, they will, if they are able to discharge their onus of proof, then fine. Then it will shift to you on the basis of preponderance of probabilities. But here it's only 482.
Your Honorable Bench, for that case, the bench may refer to the first two submissions by the respondent. That may suffice for the current.
Yes.
If the bench is satisfied, may the counsel proceed with the prayer. Therefore, in the light of the questions presented, arguments advanced, and authorities cited, respondent requests this honorable court to find, adjudge, and declare that the appeal is not maintainable under section 482 of the Criminal Procedural Code. The hotel was not under any obligation to file a police complaint on behalf of the petitioner. The Internal Complaints Committee was constituted in accordance with the law and with bona fide intention, and the statements made by Rajneesh during the hearing in front of the committee did not constitute a case of criminal defamation under section 499 of IPC, and may pass any other order in favor of the respondent that it may deem fit in the interest of justice, equity, and good conscience. For this act of kindness, the respondent shall duty bound forever pray. All of which is most humbly and respectfully submitted. May it please the court.
Are you not wanting dismissal?
Your Honourable Bench, as it has been already specified earlier, the respondent does want the dismissal of the petition.
You want to rebut? Yes. Yes, yes.
The counsel seeks the permission to rebut on the arguments stated by the opponent to counsel. Much obliged, Your Lordship. Your Lordship, the counsel wants to correct or direct the opponent counsel regarding section 18. It states the recommendations that are made under certain provisions, and the stance for which we have gone is non-initiation of police complaint and the unconstitutionality of the complaint committee, which does not fall within the purview of section 18. Your Honor, Your Lordship, the opponent counsel is quite unknown with the facts itself. First, they stated that we instantly came up with the complaint. Your Honor, we took a week, and then after a week we had come for the complaint. Secondly, Your Honor, according to them, after hearing the verdict, for a verdict we had eraded. Your Honor, rather it was for the non-initiation of the police complaint for which we had gone to Mr. CEO. Your Honor, secondly, if they were so much concerned about us, Your Honor, why didn't they call Miss Claudia? The distance between India and London is 9 hours and 46 minutes, and Delhi itself has an international airport. Owing to the traffic of Delhi as well, Your Honor, it wouldn't have taken Miss Claudia 3 months to reach over here. They could have contacted it, and neither Miss Claudia is living in some other planet that it is impossible to contact her. And regarding the statement that they said the intimate dinner, Your Honor, it is itself very, very objective word. Your Honor, everyone has a different meaning regarding it. My co-counsel would have a different meaning. Committee members would have a different meaning. Who would tell the committee members what was the meaning of the word intimate? It was respondent who had to justify. He only made a statement, and then he's saying that we are taking defense. Who would justify the word intimate? The counsel rests the rebuttal.
Yes, you want to answer? Why should we expand the meaning of this intimate, what she's saying? Its ordinary dictionary meaning is to be seen, no? Yes, come.
Your Honourable Bench, the contention of the opposing counsel is the respondent is not requesting to broaden the ambit of the word intimate. Even with a simple Google search, we can find out that the meaning of the word intimate is given as very friendly or something, or being very close to somebody. It cannot. It is the petitioner who is viewing it in a negative light and giving it a negative meaning on their part. According to Rajneesh, he did not have the intention of defaming the woman in front of the committee members. Apart from that, the opposing counsel might be confused, as we were referring to the police complaint that was filed and not the complaint that was filed to the committee. The complaint to the committee was filed within a week, but as the Honorable Bench asked the respondent that they are approaching the court right now to file a police complaint on their behalf, and the respondent did contend that we might do it now, but the contention of the respondent was non-initiation of police complaint and not about the complaint of the sexual harassment case. Also, it was also the contention of the opposing counsel that the Juan Bhutto was not at all worried about providing justice to the woman. It was already stated in our arguments that it was not possible to call Claudia, as it is very well written under paragraph 2 of the Moot prop, that she was the head of the hotel chain and was looking over the whole globe, looking over the hotel chains around the whole globe. Therefore, she was not. It was more sensible to provide a person who is available in India itself, rather than calling someone from another country who might not even be as familiar with the laws of India. Therefore, it was more appropriate for Juan Bhutto to preside over the committee rather than calling someone from outside of India, who was the only one present in this case.
Thank you. So we reserve the judgment. So we have to give the mark there.
तो कर लो